We're on a roll call on the floor, in fact, 2 roll calls, so the entire Senate is waiting for us. And please, if you be concise.
Sure. Judge Thompson, thanks for sharing your story with us. It's inspiring and grateful for it. I wanted to ask you briefly about there was a conference you attended and participated in as a presenter in 2018 at San Francisco State University's 2018 Constitution Day event. You participated in a presentation there that was called The History of White Supremacy and Constitutional Law. Obviously, there were some featured cases that stand out. You talked about Dred Scott, Plessy, Korematsu, to name a few that clearly are instances of that. There was a separate section within that presentation that focuses on, quote, present-day white supremacy and constitutional law. Is that, what are instances of present-day white supremacy and constitutional law? I'd like to know what that's referring to.
Thank you for that question. The seminar of which I was invited as a guest on the dais to cover a certain segment of cases and their holdings was what my role was in that particular presentation. I did not choose the title. I was a selected guest to talk about seminal cases. The cases that I talked about were those that were in the static history, Dred Scott, and then we moved into the 13th Amendment and how that abolished slavery. We then talked about Plessy versus Ferguson, and then how Brown versus Board of Education overruled that. And then we moved also to Pace versus Alabama, and we talked about how the case of Loving versus Virginia allowed people to marry those who they loved. And so the cases in which I discussed with the audience was the evolution of the law and how it is that we have a static history that we all have to live with. It's an unpleasant history in part, but it is there. And then we talked about how we evolve over time. And then we challenge young people to understand that history, not repeat it, and what resources we can provide them for a more diverse and harmonious community.
One follow-up question on that. On the 13th Amendment part of it, there were some notes in the presentation slide. I couldn't tell whether they were yours or another presenter's, but that raised the question, questions regarding the applicability of the 13th Amendment in context where someone had been duly convicted of a crime. And the quote in the notes said, the 13th Amendment permits enslaving anyone duly convicted of a crime. How can the courts justify plea agreements as due convictions given the duress under which many of them are obtained is beyond me. Is that, do you remember whether that was your?
Oh, I know exactly where that is. There was a moderator also. There were 2 of us on the dais, myself and Stanford professor Kathleen Tarr. And there was a moderator who would pivot between the 2 of us with questions. I made it very clear not to pose any questions to me that had to do with any policy issues or any sociological debates, that my role would be simply to go through the case law itself.
Right.
And I can assure you, if I am confirmed, no one will have any privilege above anyone else in my courtroom, as they have had balance throughout the last 20 years.
Okay. So you were a judge by then, and so you didn't want to have any part of that.
Exactly.
Okay,
Sir.
that makes sense. Thank you, Mr. Chairman.
Thank you, Senator Lee. I'm going to wrap it up now, and you may be sent some written questions by members. We ask you to promptly respond if you can. I hope you will. What you have just witnessed is a recurring debate in the Senate Judiciary Committee about criminal justice. You can play this back with every panel that comes before us in some form or another. And it reflects truly difference of opinion and philosophy, although surprisingly there are many areas where we find agreement. Senator Lee and I have worked on criminal justice reform together, and we're miles apart in terms of our political philosophies. And the same is true with Senator Grassley. And I would just say this notion of soft on crime is an important bumper sticker, but it doesn't really get to the heart of the issue as far as I'm concerned. I just don't believe convicting the wrong person is anything other than being soft on crime, nor executing an innocent person and allowing a guilty person to go free is anything other than soft on crime. I do believe that prosecuting every crime rather than targeting limited prosecutorial resources to the really important ones in the community. To do otherwise would be soft on crime. I think senators, and sadly it's not Senator Lee, but there's been a senator on this panel who's put a hold on critical players in our legal system like U.S. attorneys and U.S. marshals. That is soft on crime. We need these women and men in place to fight crime, and to hold them here for political reasons is incomprehensible to me. I think ignoring DNA evidence is not only soft on crime, it's soft-headed. If we can't look to science and respect it and what it tells us, shame on us. And finally, to call some elected officials pro-crime concerns me greatly from a panel, and this again does not apply to the senator who stays here at this moment. But there are senators on this panel who are cheerleaders and apologists for the January 6th insurrectionist mob that stormed this Capitol. It has resulted in the largest criminal prosecution in the history of the United States. 750 people have been charged so far. More to follow, I'm sorry to say. And to say that these folks were involved in some legitimate expression of political belief is disgusting and, in my mind, wrong-headed and pro-crime. To ignore the fact that 6 people died, including policemen, and 140 law enforcement officers were attacked by that mob that assaulted the Capitol on January 6th. That's a fact. And to ignore that, I just don't understand how you can, and I hope we never will ignore it. I thank you all for being here today. You've seen a slice of America's debate, and some of you have been in the middle of it and have been for a long time. We respect